count 3, felony murder, aggravated assault with a pickup truck. Your Honor, although the statute defines the grounds for a directed verdict, I believe Ms. Dunikowski has acknowledged that it's not that simple, that the standard essentially goes back to Jackson v. Virginia. It's not just whether there's quote-unquote any evidence to submit something to a jury. There has to be sufficient evidence from which a rational juror could find guilt beyond a reasonable doubt. There is a severe lack of evidence in this case. There's no evidence that Mr. Bryan intended to do so. What they're doing is they're basing that on words, and I'm going to incorporate here for purposes of the motion for directed verdict the arguments made in connection with the special demurrer in this case. And of course, those have also already been addressed to some extent by counsel for the McMichaels. Your Honor, there's no witness. There is no witness to what Mr. Bryan did. There's no video of an aggravated assault. It's all contradicted by the physical evidence in this case. And I don't have the citation in front of me, but with respect to aggravated assault with a motor vehicle, I think the case law, there is a case specifically out there that says speculation as to aggravated assault is inappropriate. And there are some times when there's insufficient evidence and where the jury is basically being asked to speculate as to what happened. And this is that case, Your Honor. And with terms of felony murder, again, you get back to the same issue. Assuming for the moment that Mr. Bryan was committing an aggravated assault with a pickup truck down on Burford, how does that establish, how is that the proximate cause of a felony murder that takes place down on Holmes Street later? And for the jury to be able to return a verdict, because of the way this indictment is phrased, the jury can return a verdict of guilty without specifying where it takes place. How do we know that the jurors, certainly all 12 of them, have made a decision as to that? Because without that, how can they make a determination as to proximate cause? This is a huge problem. And I'm going to get back to count 7 in a moment. But in terms of felony murder, there's just no proximate cause here. It's not reasonably foreseeable. And it's a huge stretch to say that what Mr. Bryan is doing out there in his truck is causing the death. In fact, I think the McMichael lawyers have already pointed out that their truck is stopped. It's not even moving. And Ms. Dunikowski talks about revving the engine, but I think the video speaks for itself. Certainly Mr. Arbery is not assaulting at this time. Your Honor, there's no proximate cause. There's insufficient connection to the death. I'm going to turn to count 4, felony murder, which is based on false imprisonment. Your Honor, I do believe that there was a special demurrer filed in this case previously about false imprisonment. And if I recall, the court cited a case, and I don't have it in front of me, about you can imprison with a pickup truck. My recollection of that was a case where not just where someone was being chased, but where they actually were struck and went over the hood, and then the person in the car got out and did a stabbing. That's certainly factually distinguishable. But again, what is it if the false... At the time of the shooting, there is no false imprisonment, Your Honor. At the time of the shooting, Mr. Arbery, to borrow a football phrase, has broken containment. He is past both trucks at that point and has a clear line to the exit to the neighborhood. So I don't understand how you could have proximate cause between a false imprisonment, if that's what it is, and the shooting itself. Because there isn't. I'd also contend, notwithstanding Georgia law to the contrary, that false imprisonment is not the kind of felony that will support a felony murder charge. There are other jurisdictions that disagree with Georgia, and under their laws, they do not view false imprisonment as a violent offense that would be a felony you could base a false imprisonment on. I certainly want to preserve that argument. Because it's just, I guess the best way to phrase it in terms of Georgia law is false imprisonment really is more like a status offense than it is a violent offense. And in that respect, it should not be the underlying felony for a felony murder charge. We still have issues with the mens rea. We still contend that the false imprisonment is unsupported factually. But again, in terms of foreseeable, how is the shooting, Your Honor, reasonably foreseeable to Mr. Bryan, assuming that there is a false imprisonment? How is the shooting itself? It's one thing to say that Mr. Bryan aided and abetted a false imprisonment. That's not the same thing as saying he aided and abetted a shooting. And that, again, goes back over ground I think I've already covered, and I won't do that to the court again. Count 5, felony murder. Again, we contend that criminal attempt to commit felony murder is not the kind of offense upon which a felony murder charge can be predicated. We would suggest to the court that is even a step further removed from false imprisonment itself, and that furthermore that the attempted false imprisonment is not the proximate cause, again, of the shooting or death of Mr. Arbery. There are real problems there with a causal link. Count 6, aggravated assault with a shotgun. Again, there is no aiding and abetting for Mr. Bryan. Aiding and abetting a citizen arrest, even if unlawful, is not the same thing as aiding and abetting a shooting. And I won't go back down that ground any further. Count 7, aggravated assault with the trucks. Co-counsel has already spent a good bit of time addressing this. I've addressed it in the special demurrer. It's troubling to me that the state comes in here when 3 police officers, Your Honor, 3 seasoned police officers, well, 2 well-seasoned, 1 we could argue about, all interview Mr. Bryan, and that's the basis of this count, is Mr. Bryan's statements himself. There's no other evidence other than that in this case. And all three of these officers interviewed Mr. Bryan or talked to Mr. Bryan at length. All 3 summarized those interviews. None of them refer to Mr. Bryan's conduct as an aggravated assault. None of them do that because it's not there. The jury, Your Honor, is required to get to the truth of the matter. It's not just the words that Mr. Bryan uses, anybody's words can be twisted out of context. It's the context in which they're given. It's the meaning that's meant to be conveyed. And it's clear from the testimony of the state's own witnesses that that meaning is not there. There is no aggravated assault with Mr. Bryan. And I'm jumping back and forth here, I guess, make sure where I am. Your Honor, the evidence is, in terms of the speed, for example, that while the state refers to Mr. Bryan as chasing, that the evidence is on the video is at 2 miles an hour. Your Honor, with respect to count 8, the false imprisonment, the indictment alleges, and the state is stuck with the language in the indictment, that that the confinement and detainment occurs on Holmes Drive. But the evidence that the state is relying on is coming from Burford, and he can't be convicted at this point of that. And how the court would charge the jury, I have no idea. Your Honor, on count 8, the false imprisonment, I talked earlier about the breaking containment. There is some Georgia case law out there, and for example, I guess this is the best analogy I can come up with here. In a bank robbery, when an individual committing a bank robbery pulls out a gun and tells everybody to get down on the ground, under Georgia law, that is a false imprisonment because they get on the ground. But this case isn't the case where they get on the ground. Mr. Arbery never submits to being arrested. And in this case, this is what the state is pursuing here is the equivalent to someone in a store saying, everybody get down on the ground, and the person just continuing to run right out the door. That's what we have here, and that is not a false imprisonment under Georgia law. And again, if Ms. Dunikoski has a case citation for this court to any Georgia case that is remotely factually close to this one, I'm sure she'll present it. But I can't find it. Your Honor, attempted false imprisonment, that's count 9. We contend that the evidence is simply insufficient to submit that matter to the jury. Moreover, we think the evidence that was presented during the state's case in chief shows affirmatively abandonment. That Mr. Bryan has abandoned this chase, as they call it, and the video itself, I think, demonstrates that at the time of the shooting, Mr. Bryan is simply a witness to the shooting itself and to those events. And under those circumstances, we believe that he is entitled to have an acquittal as to count 9 and all the other counts in this indictment. We would ask that a directed verdict be granted on all counts and that Mr. Bryan be released forthwith.